Well. Sounds like look what the cat drug in. Miss Lundy, go ahead.
Good afternoon, Your Honor. Ashley Lundy Feltus for the people. At this time, Your Honor.
Wait, no.
I know.
No. We're not changing names.
Okay.
I've known you since law school.
Wait, now you get to know me with a new name. Say it again. Feltus.
All right. No, we're not doing that.
No, yes, we are, Your Honor.
No. Well, hold it. Is it hyphenated?
No.
It's going to be what?
Feltus. But I'm in the process of changing it with the association. Londy is the new middle, so it's new name.
We're gonna need a proper spelling for the record.
I will send it in a chat to Anna. At this time, we move to waive any.
You are messing with my whole day.
Sorry.
My whole day. I was in a good mood. All of these people expected me to be in a good mood, and now everything that happens is her fault. Go ahead, Miss. Was it Feltus?
Feltus.
Feltis?
TES.
You don't even spell it right. Go ahead.
Yes, Your Honor. This time we waive any conflict in this honorable court in the Office of Public Defender. People do not believe that any conflict exists to make a waiver of the avoidance of all doubt.
Parenting, right? Still?
Yes.
Okay, go ahead.
Same name. Assistant Public Defender Lauren Kearney, the Public Defender's Office, likewise does not believe the conflicts exist, but if one does, we also waive.
The court, for its part, also does not believe that there is a conflict either in the Michigan court rules or the cases decided there. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Don Damer.
Ashley Feltus for the people.
Come on, I'm not mad at you.
Your Honor, Assistant Public Defender Lauren Kearney. Your Honor, this is an expungement that although the Public Defender's Office is the attorney of record on the case, we did not file the expungement on behalf of Ms. Dameron. However, we did handle the underlying case. So I don't have any information on this file.
All right, very good.
Hello,
What's your name?
Dawn Dameron.
All right. And you're seeking to expunge one conviction of operating while intoxicated, is that correct?
Yes, sir.
And Your Honor, for the record,
yes.
People, I have done a little bit more research into this. If the court has the information from the Attorney General with the iChat printout, the court may note that there's a 2018 conviction for operating while intoxicated third offense.
You said that came from the AG?
The information I have set aside with the letter includes the iChat, and I can also report with it as well. I say that to say, and it may be with the original petition. I'm not entirely sure how it comes to the court's file, but I was able to find a June 7th, 2018 conviction for operating while intoxicated third offense, which then led me to find that complaint, which does indicate that Ms. Dameron unfortunately does have two prior convictions, a 1997 conviction, as well as this 2007 case that we're here on today. So unfortunately, Your Honor, I do believe that this was not her first OWI offense.
Right.
And I would therefore have to object to it being set aside at this time because I do not believe that it is a true first offense. I think that while it may have been charged as a first offense because the 2007 case would have been outside of the 7-year requirement from the 1997 case, it is technically a second and should therefore not qualify under the statute. I have a copy of the complaint from the 2018 case if the court wants to review that.
Okay, I have the 2018 case you're talking about is the third offense.
Yes, Your Honor. That's sort of what prompted me to go looking a little bit more into it.
And I see that on some of the information we have. And then I see ours from 2007. Correct. Okay. Ma'am. Anything you want to say?
Judge, yes. That was when I was a little younger, was going through dumb stuff, didn't know no better. I've grown up now. I'm doing better. I work at the U of M. I'm trying to stay on the right path, do what I have to do. I have grandchildren and stuff, and I'm just trying to improve my life so that I can do better for my grandchildren.
And ma'am, I am very much supportive of that notion, except that I don't think I'm permitted by statute to set this aside.
Okay.
All right.
And when I got those other two DUIs, I had lost my sister, and that just caused me to drink my last DUI I had, because before then I didn't, like she said, I didn't have another one until 2000.
Everyone swears they remember, but memory bends under pressure. It becomes a tool, a weapon, or a shield. The prosecution wants certainty. The defense thrives on doubt. And in between those two blades stands the truth, shaking, trying to survive the story being told about it.
2007.
Gotcha. No, and I understand all of that, but what Miss Feltus has indicated is that she, in looking at everything, this conviction is really not eligible for me to set aside in any event. And she's correct. So, regrettably, I'll have to deny your petition to set this one aside.
Okay.
Okay.
Mm-hmm.
If you think that there's some error in that regard, certainly contact the public defender's office. They'll be happy to kind of look at it and go through it with you.
Do you know about when you think I'll be eligible to do it, if ever?
I can't give you advice in that regard. The statutes are constantly changing in respect to what can be set aside and who can set it aside. But I'd suggest contact the public defender's office, and they'll be able to kind of let you know and guide you through it.
Okay.
Okay.
Mm-hmm.
All right.
Thank you. Have a good day.
You do the same. Court does call the cases of the people versus Brooke Abe.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Habe. Ms. Habe, can you state your name for the record, please?
Yes, Brooke Habe.
Habe. We're putting too much emphasis on it.
That's okay, you were close.
Your Honor, we are here for expungements on two separate cases. We do believe that Ms. Habe is statutorily eligible for expungement, and we did receive a letter from the Attorney General stating the same. And I do have some words on behalf of Ms. Habe when the court is ready.
I'm ready. Go ahead.
I don't know if the court got her letter and her letters in support, but she did write a pretty lovely letter that I was able to review while prepping for this hearing. And I won't read the whole thing, but I do want to summarize some of the things that she wrote about. She talks a lot about how different her life has been since these incidents and now. Since then, she has become sober. She says that she fully embraced the principles of Alcoholics Anonymous as a guiding force in her life. She's an active participant in weekly meetings, working the 12 steps, and maintaining contact with her sponsor, as well as developing relationships with other people in recovery. She has brought this mentality into her work as well. For 6 years, she's worked in Lenawee County in substance use prevention. She works as a prevention specialist and works with high school, or well, I guess K through 12 students, helping them build tools to avoid falling down that path. She also serves as a coalition coordinator in Lenawee County. She has introduced Narcan to first responders in the community. She works with the Lenawee County Sheriff's Office and the hospitals there on their Take Back initiative. It goes on. She chairs Hunger Free Lenawee, which is an organization dedicated to fighting hunger in Lenawee County. So she has brought these values into her everyday life outside of only her, her home. She further
The judge doesn't yell to control the room. They don't need to. A single pause, a quiet stare, that's enough to make even the toughest attorney stumble. Silence is the most dangerous weapon in the courtroom because it forces everyone to listen to themselves.
writes that since these incidents and since these changes, the best part about the change has been repairing her relationship with her daughter, and moving past her addiction. She would like these expunged to improve jobs and things like that. She writes that she had, because of these, had issues with being denied housing or employment. She wants to expand her work of prevention education, reach more youth in schools, and grow further in her field.
So in other words, she doesn't do much during the day.
No, I think she's got quite open schedule.
Just kind of lays around all day and does nothing, doesn't help anybody. I got you. I get the picture. All right. Ma'am, is there anything you want to tell the court?
No, thank you for that synopsis of my life. Yeah, no, I really am, I do not regret the past or wish to shut the door on it. And also, I just want to kind of move forward from this. It has been a long and wonderful 10 years. There's been substantial growth in who I was to who I am today. And just having this opportunity to kind of clear my record would do a lot for me. And I also think that it would do a lot for my community as well. I'm very active in the recovery community here in Lenawee, as well as Washtenaw, and having this expungement would allow me to do more and reach more people.
Just as I was listening to what Ms. Perrine was saying, I meet a lot of impressive people who, when I first met them, that probably wouldn't have been the first thing that came to my mind. But just listening to what you do, how you sort of changed things for yourself, and made something positive. Quite frankly, I don't think it really doesn't matter what I do here today, because I think what is ingrained in you and what you've been doing wasn't solely to get to this. It's about who you are. Mm-hmm. And so I guess what I was going to say is it really doesn't matter what I do. You're going to continue doing the good things that you're doing. The other thing that for me, that's of note is, as Ms. Perrine was talking, she said one of the things that's most important is repairing your relationship with your daughter. How old's your daughter?
She will be 18 in September. She was just accepted to U of M, and we are moving her in. So she will be.
Hold on. You have to realize something. That's like a Wolverine thing, right?
It is, yeah.
Okay, so you have to understand that you're talking to a judge that U of M for me is University of Maryland. Oh. So if you're telling me you're going to that blue and gold place, okay, well, whatever. Okay, second rate, it doesn't matter. No, go ahead. I'm sorry.
Well, we're pretty proud of her.
No, and you should be. That is fantastic. A lot of people always they look at the young person and they congratulate them. I always look at the parents and I congratulate them, because it takes a lot to get them there. Be nice if it's an easy road, but it's not quite that all the time.
No, my work that I have done personally directly affected Ari in her ability to thrive and have the support and the protective factors that she needed to be the person that she is today. And so I'm incredibly proud of her, and I'm incredibly proud that I was able to be a part of that.
That's a lot of good things I hear. That's one of the greatest things. But something tells me, I don't know your daughter, but something tells me in a lot of ways, probably that apple doesn't fall far from mama's tree. So I think a lot of what you are was instilled in her. So, all right, that's fantastic. So, ma'am, the court does believe that the circumstances and behavior of the applicant from the applicant's convictions to the filing of the application do warrant setting aside the convictions. And the court further believes that it is consistent with justice and the public welfare. And so, for those reasons, the court will grant both of these petitions to set aside the convictions. And ma'am, I signed your orders. Congratulations. All right.
Thank you.
Don't, have you moved your daughter in already?
Yes, she moved into her apartment. Yeah.
And that was hard, wasn't it?
She still has to.
The law loves logic, evidence, statutes, precedent. But when the lights dim and the cameras stop rolling, cases don't run on logic, they run on instinct. You can't measure guilt, you can't quantify remorse, and you can't predict what fear makes people do. You can only watch and feel.
Come back once a month or less, or else she'll lose her room.
Okay, all right. Good enough. No, that works. Okay. I like that. All righty, ma'am. You take care of yourself. Be safe out there. And although, like I said, your daughter doesn't know me, if you get a chance, wish her the best from this judge. I think she'll do well. All right.
Thank you.
All right. Take care of yourself.
Thanks.
Court calls the case of People versus Jimmy Lee Mack.
Ashley Feltus for the people.
Good morning, Assistant Public Defender, or afternoon. Lauren Perny on behalf of Mr. Mack. Your Honor, the public is attorney of record on the underlying case. However, we did not assist Mr. Mack in filing the expungement, so I have no information regarding his petition.
All right. Go ahead, sir.
Jimmy Mack Jr. for the record. I do have, if the record doesn't reflect the letter from the Attorney General, I do have a copy of it.
I have it, sir.
Persistence is key, Your Honor. Persistence. I wanted the record to reflect things, so that's why when I was before you at first, my criminal history wasn't updated with the AG office and everything went through. So that's why, yeah.
I remember.
And Your Honor, the most recent letter I have from the Attorney General is March 17th. Is that what the court has?
Let's see.
Date on the letter is February the 18th.
June 26th, I turned in the copy to the.
From the Attorney General, I have a June 26th, 2025.
Okay. I didn't get that, but I'm sure. Can I make a copy of this? I didn't get that, but I'll give it.
Okay. Okay, go ahead.
Well, Your Honor, basically, I'm here before you again. Basically, just trying to get my life in order, as you heard before in the other proceedings, and expand my outreach.
When a judge speaks, the words echo far beyond that room. They follow the guilty into prison cells, the innocent into therapy, and the lawyers into sleepless nights. Every sentence isn't just a decision, it's a haunting. Because justice doesn't end when the gavel falls, it lingers.
In the community, and better myself and others in the community. And pretty much, my record is even cleaner than what the court has as of now, because I done had some other things that was updated on my record. So even though it does say I'm already eligible, but I'm extra eligible now because
Extra eligible?
extra.
Extra. All right, go ahead. All right. Well, I've looked over everything and yes, persistence, sometimes you just have to have it, right?
Yes, sir. Yes, sir. Gotta persevere.
All right. The court does believe that the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of this application do warrant setting aside the conviction and is consistent with justice and the public welfare. Therefore, sir, I will, this time around, grant your petition to set aside the charge, and I have signed that. All right. Sir. Take care.
Thank you.
Court does call the case. The people versus Andrew Peggs.
Ashley Phelps for the people.
Good morning. I'm sorry. Good afternoon, Your Honor. Evan Ford, P 80829, on behalf of Andrew Peggs. Mr. Peggs, please state your name for the record.
Andrew Peggs.
This is Mr. Schiller.
Oh, no wonder I didn't have.
Okay.
I apologize, Your Honor. I'll withdraw that.
Okay. All right. Go ahead, counsel.
So, Your Honor, we are here on the motion to set aside a conviction from 2000. This is Mr. Peggs' first operating while intoxicated. We have received responses from the Michigan State Police as well as the Attorney General's office. Mr. Peggs has not been convicted of more than 3 felonies. He does not have any pending criminal charges, and he is not on probation or parole. Following this conviction, Mr. Peggs was ordered to attend a weekend alcohol retreat. He also completed a 6-month inpatient retreat at Dawn Farms in Ypsilanti and was an active member of AA for 4 years. These programs helped Mr. Peggs to realize he did not have a sense of self, which resulted in him creating a life surrounded by alcohol. He now has developed a different personality and better coping mechanisms outside of alcohol. Mr. Peggs spent some time living in Utah following his conviction, and while there, he spent 8 years working as a counselor at Second Nature Wilderness Program. During that time, he worked with youth dealing with drug addiction and dependence. He is currently employed as a platform architect with Rocket Clothes and holds several CompTIA certifications. Mr. Peggs is engaged and a father of 2 boys, ages 13 and 8. He gives back to the community in various ways, including donating blood and volunteering with Gleaners Food Bank and the DPS Distribution Center. Mr. Peggs has worked hard to overcome his alcohol addiction and is not the same person he was 20 years ago. His hope is that this expungement, or by expunging his record, it will help to improve his life in various ways, including with his license and insurance. So given these factors, we do believe it would be in the best interest of public welfare to grant this expungement, and we ask your honor to grant the motion to set aside the conviction.
And Mr. Pegg, anything you'd like to tell the court?
I mean, listening to everybody else, there's a lot of similarities. I would just like to say I'm really, it's a blessing that nobody got hurt when I was making all of those bad decisions almost, 25 years ago now. Other than that, I don't have any regrets. Those decisions are what made me who I am today. I'm a proud father, and my hope is that, I have no plan of keeping my past away from my kid. I think that there's a lot of lessons there, and I think that this is expungement could set an example for him as well, that even though people can make mistakes, they can learn from those mistakes and do better and be better.
You can actually learn from your mistakes.
I I've even gotten to the point of learning from some other people's mistakes, but that's a bit
Yeah,
that's a
right.
bit
Okay,
fewer
well.
and farther between than my own.
I don't think any of us as human beings would be able to move at all if we didn't learn from mistakes, right? Because I've yet to meet perfect human being walking this planet that hasn't made a mistake. So how'd you like Utah?
I loved Salt Lake City. I
Yeah.
was skiing. Yeah, it's a great city. Just the inversion smog was not great.
No, right. But it actually, what I like about it is the area out there is beautiful. So that's
Oh,
what
absolutely.
I love about it. All right. Having listened to counsel and the petitioner, Mr. Pegg, and an opportunity having given for the Attorney General and prosecuting official to contest this application and hearing none, court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions, and also believes that it is consistent with justice and the public welfare to do so. And so therefore, sir, I will grant your petition and your conviction is set aside. All right. You
Thank
take
you.
care of yourself.
You do
Thank
the
Thank
same.
you, Your Honor.
Thank you, counsel. Take care.
You as well.
Court calls case, People versus Spencer Fry.
Ashley Feltus for the people.
Ain't gonna work.
Mr. Fry is in Zoom.
Yes, Mr. Fry. Who is this counsel?
I just unmuted it.
All right. Sir, do you know where your attorney is?
Let me see now. I think he was running a little behind schedule. He was in a court proceeding. I think he'll be, let me look now. He said he's wrapping it up. He'll need about 5 to 10 minutes. Before you can sign on.
All right, sir, what I'm gonna do is I'll stand in recess. We'll leave it up and see if we can get to you. I've got a preliminary exam starting, so that could be part of my problem in getting you in, but we'll figure out a way to get you in. It may be a bit. All right?
Okay.
Thank you.
All right, cool.
Court stands in recess.